I'm Justin Silverman of the New England First Amendment Coalition. Thank you all for joining this month's 30-minute skills class on how to respond to a subpoena, led by Matt Byrne, an attorney at Gravel Shea based in Burlington, Vermont. A couple quick announcements. The first, reminder, all of our previous 30-minute skills classes are available to you to view. Just go to nefac.org, click on the 30-minute skills banner. If you're watching this as a recorded presentation, just click through to our YouTube channel. You'll see a playlist there with all of our previous classes, including 2 on data cleaning, led by Maggie Mulvihill at Boston University. Well worth a view, very valuable instruction. Please check it out. During the course of this presentation, feel free to use the chat box at any time to ask a question to Matt about his presentation. Very much a conversation that we're going to have here over the next 30 minutes. So please feel free to ask any questions as we go along. We'll also reserve a few minutes at the end for any remaining questions, and Matt will get to as many as possible. With all that said, I now present you Matt Byrne.
So I like to start out with the end goal in mind. And the end goal is, what do you want to have happen at the end of the subpoena process? And for me, what I'd like to see is for you to have your cake and eat it too. And what does that mean? Well, I want you to protect journalistic independence and not go to jail. I think those are both very valuable goals, and I think everybody would agree with that. And the issue is that you're going to need a lot of finesse to achieve that goal. And hopefully, work with an attorney, you'll be able to, protect journalistic independence and not go to jail. So let's step back. We know what the goal is. Let's talk a little about what a subpoena actually is. A subpoena is a command by the court to do something. In general, there are 2 types of subpoenas. The first is for documents, and using the Latin, sometimes you'll see it's a subpoena ducis tecum. And the other type of subpoena is for testimony. And that is, using the Latin again, is called ad testificatum. And fortunately, we don't have to speak Latin anymore. But what in essence they are is you have to either show up and give documents, or you have to show up and testify about things, either at a deposition or a trial. Now, there's the thing that's unique about subpoenas, at least in the modern day, is that they come not from the court itself. They actually usually come from lawyers, and the lawyer will fill out the subpoena and let you know what it is they want. And so that actually helps you with the court sometimes, because lawyers tend to be a little bit overzealous and they tend to ask for too much, and courts understand that. So what's at stake? Well, the big picture ideas are the independence of the press and the power of the court. Practically speaking, defiance of the subpoena. What's really at stake? Well, the court's power to get you to comply with the subpoena is to send you to jail. And, did you pack your toothbrush when you go to your contempt hearing? What else is practically at stake? Well, where can you actually be most effective? You aren't breaking many stories in jail. So as a journalist, you have to consider, what exactly are you hoping to achieve? And can you do your job better out of jail than you can in jail? I mean, theoretically, you could do a piece on the prison conditions, but there are a lot more stories out of jail than there probably are in jail. And then what else is practically what we're thinking about? Well, we want to delay the date of decision, the ultimate reckoning, as long as possible. So where does the court's power to get you to comply with subpoena come from? Well, it's from its contempt power. And so in exercising its contempt power, or in your decision to force the court to exercise its contempt power, what do you want to consider? Well, to me, I'd like to represent people first and foremost, and I also really believe in the First Amendment and those things. But to me, it comes down to a lot of personal factors. Like, does the journalist have a family? How old is the journalist? Do they have a desire to be the journalistic superhero? There are, in fact, journalists who have stuck up for their principles and gone to jail and waited at the court. Ultimately, a lot of times they comply, but they make the point that it's important to protect journalists. So I also want to help you understand what motivates judges, so we can minimize the chance that they're going to try to do something like hold you in contempt. So what is it that courts have? Well, courts institutionally have a self-esteem problem. When push comes to shove, courts actually have little power in our structure for balance of powers to enforce their orders when the executive objects. There's a very famous case involving Andrew Jackson, President Andrew Jackson, and one of the big Chief Justices, John Marshall. And they had a confrontation, and John Marshall ordered him to do something. Andrew Jackson just flat out refused. Well, I mean, that's interesting from a historical perspective, but guess what? It's not really going to matter for you. The courts have enough power to force a journalist to do something against their will. And usually in these situations, the executive is going to be aligned with the judiciary, like a prosecutor is the executive, and they're going to be aligned with the judiciary, and they have enough power to force you to do what you should do, according to them. And basically, you're not Andrew Jackson. So where does this court's contempt power come from? And this is a quote from a famous case involving the contempt power. That really scares me is they call it an inherent power. And what does that really mean? Well, it flows from the nature of the institution. And what power do they have? They have the power to impose silence, respect, and decorum. And these powers are governed not by any rule or statute. And this is from a Supreme Court case in 1991. Well, let's break that down. From the nature of the institution, that to me as a lawyer goes, uh-oh. They're not really talking about anything specifically, but what this nebulous nature of the institution is. Well, they have the power to impose silence, respect, and decorum. Guess who gets to decide if you are showing respect? It's not you, it's the court. And their judgment is largely unquestioned. And that's from a justice standpoint, that's a little bit troubling. And then they say that the powers are not governed by rule or statute. And that's another uh-oh, because it's not really written down. It's more of a situational determination, and it doesn't really involve the other branches of judgment. So there's no sort of checks and balances involved there. Okay, hopefully I've gotten your attention and you say, look, a court can just throw me in jail because they decide that I'm not being respectful. Yes, that's true. So, rule number one, actually there's a rule before this, which I would say is get a lawyer. If you're involved in a situation where you're trying not to comply with subpoena, you really should have a lawyer to help you figure out how to do this. So what's the next rule? Well, rule number one is be nice, right? And it's probably goes without saying, but it's really much harder for a court for you to offend the court if you're trying to be respectful. And I'll give you the example of when I was a kid. We had a bus driver, her name was Mrs. O, and she really was a totalitarian bus driver. But my brothers and I had a different reaction to her. Got in trouble, but my brother Vince, he continued to be completely defiant. And guess what? He got a complete ban from the bus because she used her discretion against him, and he got completely thrown off the bus. Me and my younger brother, Andy, well, we were a little more accommodating and a little more, trying to be respectful. And guess what? It actually worked out for us because we got to ride with Lou, the cool bus driver, for the rest of the school year. And it really wasn't much of an inconvenience at all. So the way that you approach the decision maker, if you're nice and you're careful and you're respectful, can have a huge impact on the type of punishments you have. And that's true with bus drivers, and it's also true with courts. The next rule is really know your audience, right? As a journalist, you write to your audience and you try to deliver them the information that they need to make decisions, or, political reporting or entertainment reporting or sports reporting. You're really trying to be useful to your audience. Well, as a lawyer, what we're trying to do is we're trying to persuade our audience, and sometimes it's a jury, but often it's a judge and it's one person. So you really have to understand that particular judge to make the best decision that you can. Like I say, for us in a contempt proceeding, it's going to be the audience of one, the judge. And so there's some helpful techniques in dealing with a judge that will help you get through the process. The first and most important is don't ignore it, right? Judges hate that. They really hate it when somebody, there's something important going on and, they get delayed because somebody doesn't show up or doesn't respond to it. So ignoring it and hoping it will go away is the exact opposite reaction you need. You should respond in writing to a subpoena. If you have objections about the subpoena, objections in writing. If it's too broad, it really asks for a lot of things that aren't relevant. You have a confidential source, that's a really important one. If you have a relationship you're trying to protect, put that down in writing. If the court schedules a hearing, and a hearing is where you actually have to show up in person, go to that hearing. If you don't show up, it's a default, and they can just issue arrest, and then you go from there, and that's not a good place to be. So what arguments actually work? Well, we talked about the big picture, which are the constitutional arguments, but really the ones that work are the simple ones, right? Be polite to the judge, right? Thank the judge for your time. And if you're at that hearing, say apologize to the judge for the burden, right? Something I might say is, Your Honor, thanks for taking the time to listen to us on some very important concerns we have. And we're sorry for having to take up your time with these issues. But, you say, this has nothing to do with the First Amendment. You know what? You're right. You're absolutely right. It has to do with respect and the power of the court, right? And as a young lawyer, I argued, First Amendment public access case, and I started saying, look, this is essential to stopping fascist government. You really don't want to be doing this. You got to have accountability to people, which all makes sense. But guess what? Judges have heard it all before, and they weren't really impressed with the fascist argument piece of it, right? They understand what's at stake, but being a little too extreme and a little, values don't always work. So some of the simple arguments are the ones that work the best. So why is that important? Well, it's important because judges exercise discretion, and we're going back to the case that the Supreme Court decided. And it talked about the inherent powers, right? Because of their very potency, the inherent powers must be exercised with restraint and discretion. Well, what exactly is discretion, right? In the legal sense, what that means is the trial judge, the one that you're appearing in front of when you first get the subpoena, they have a lot of leeway. They have a lot of room to make a decision that fits the facts. And appellate courts, even though we will get an appeal, right, and we want to talk to the appellate court about the important First Amendment issues, they really review the lower court decision with a lot of deference. They don't really like to reverse a trial judges, particularly when they're talking about contempt and the inherent powers of the court. So they're not likely to overturn it. That's the bad news. The good news is that most judges tend to be good people. And that's something to keep in mind. The judges I know are reasonable, and they understand that there are important issues at stake, like the First Amendment, shield laws, and they want to let you say what you need to say, and they really don't want to do something mean to you. So that's why being respectful is important. They also have discretion as to punishment, right? They can say what the level of punishment is, right? And they can also have discretion about when to impose that punishment. So a lot of times we've litigated the subpoena issue, and they aren't anywhere near to talking about jail time because we are respectful and there are important First Amendment issues. So we let them know, look, we want to litigate the First Amendment or the shield law, and we would like to do that without you being in jail, which is a very important thing. And this is ultimately where the being nice pays off, because you can get the legal issues argued and then, continue to do your job. So what would we say? We would say something like, look, we have the utmost respect for this court and its orders, and we hear what you're saying. This is after they've ruled, right? They'll rule and say, look, you must comply with the subpoena. And so then we go into the mode of, look, let us have a chance at the appellate court. And that's what happens. So we hear what you're saying. You can't say you're right because then you'll lose, but you say, we hear what you're saying, we respect your opinion, but we do think there are important issues that the appellate court needs to give all journalists guidance on. And we request that you suspend your judgment until the appellate court has a chance to weigh in. Well, what else can you do? We have a question in the chat box. How exactly is a subpoena issued? So there are a number of ways that they can actually be issued. Oftentimes, you'll just get them in the mail. So in a civil case, you'll get a subpoena in the mail, and it will say on the top of it, subpoena, and you'll have to comply with it in the mail. Sometimes, in some jurisdictions, a law enforcement officer will actually show up at your newsroom and hand you the subpoena. That happens more often in criminal cases, especially when there's time limits. Like it could be some witness testimony comes up and they'll issue a bench subpoena or a trial subpoena that you have to comply with immediately or within a day or two. And that's when you really should have your attorney on speed dial for that sort of situation. So they generally come in either in the mail or through a sheriff that's serving it on you. Let's see. How does the court, so does someone in the uniform show up at your door? Yes, that can happen. It can also be snail mail. Email usually doesn't happen. So if you do get an email, it's probably a phishing scam, but you should still probably talk to somebody. How does the court find you, right? the subpoena may be issued to the newsroom or the entity itself, and it's not that difficult to find the entity, like like the New York Times, you know what their address is, and you go from there. And if you're traveling or you're not checking mail, that again, it usually goes to the newsroom. They're going to serve the entity itself. It's not usually going to come to the reporter. And if they don't, the other important thing is if they don't find you, they can't serve it on you. And the judge, the power of the court doesn't attach until you have notice of the subpoena itself and an opportunity to be heard on it. So if they don't actually serve you, then some of the issues sort of go away. So let's talk a little bit about the prosecutor. So there's another way to get around this type of thing, is you just talk to the prosecutor or the person serving subpoena. And we've done this. We've talked to, people in the state's attorney's office and try to educate them on the issues. And a lot of times you can get them to back off. The other thing that's interesting is they may have a policy limiting subpoenas to journalists. For example, the United States Department of Justice has guidelines for using subpoenas on reporters. And it's actually decent because it does put some limits on the Department of Justice's ability to issue subpoenas to you. So what are the substantive arguments? Let's talk a little bit about that. If your jurisdiction has a shield law, use it. This is actually a really good technique for preventing it. Let me tell you a little bit about what a shield law is. A shield law gives additional protection to journalists so that they don't have to respond to subpoenas, right? It fixes some problems with the First Amendment jurisprudence. Vermont has a shield law. It's at 12 VSA section 1615. And for those jurisdictions that don't have a shield law, you should work with your advocacy organizations to get one. They're very, very helpful for journalists, particularly when you're protecting, confidential sources, where a lot of the tension comes up with subpoenas because they want you to reveal what some anonymous source said about a drug deal or a government whistleblower or something like that. So having the shield law really helps you there. Let's talk a little bit about First Amendment protection. I would call it rickety. It's not a legal term, but it's my general feel for it. And where does it come from? It comes from this Supreme Court case decided by Byrne White. He wrote the majority opinion. And it's frankly a mess. It's a 5-4 decision, but there's a concurring opinion. So what happened? The majority opinion said that news gathering does not outweigh interest in law enforcement on these facts. And that, I know a lot of people who at the time were very disappointed in that because they really believed in the freedom of the press. But the majority opinion said, but the subpoena must be issued in good faith. Well, it kind of got a little bit confused because I think the author of the concurring opinion, who made up the 5th vote, ended up saying, well, I'm not sure I really agree with the majority, but I'm limiting the holding to the facts of this case, which is another way of saying this is a very narrow decision. And then the concurring opinion set out a test, and it said that you also have to consider, whether it's connected to the investigation and if there's a confidential source involved. So what happened after that? Well, certain circuit courts of appeals have expanded Brandsburg. There's a First Circuit, which for those of you who don't know, it's Maine, New Hampshire, and Massachusetts and Rhode Island. And in the case of, it involved Microsoft Corporation, and Microsoft was looking for evidence from academic researchers. And what did the court say? It said, well, when a subpoena seeks the divulgement of confidential information compiled by a journalist or an academic researcher in anticipation of publishing, the court must apply a balancing test, exactly what the concurring opinion said. So you can, when you get the balancing test, you can make some headway with the court, where you talk about, it's really important that I protect my confidential source, not really that important to the investigation, they can get it from other sources. So that's exactly where you want to be. In the Second Circuit, Connecticut, New York, and Vermont, the court also said that there must be some protection on the First Amendment. The courts must recognize that the public interest in non-disclosure of journalists as confidential news sources will often be weightier than the private interest in compelled disclosure. So that's what the private interest in compelled disclosure outweighs that. So in the Second Circuit, they have gone back a little bit by it, but it is there and lawyers can do that. Now, I got a question from Mike. He says, you mentioned talking with the prosecutor, but I assume you mean an editor or a lawyer having that discussion. My preference is that the lawyer have the discussion with the prosecutor and keep the client, the reporter, and the news organization informed about that. So you really, if you start talking with the prosecutor, that usually, you don't want to do that, because then you're giving the information, just like journalists ask questions, you will end up giving information to the prosecutor that the prosecutor will then use to expand the subpoena and move on. So there was another question about how long do you need to hold on to records and notes. That is an interesting question. It's not something that you can really talk about, answer in a few minutes, because there's a lot of considerations to holding on to things, including tax consequences and all that sort of stuff. So I probably can't give you a good answer in the time that we have left. Let me continue here a little bit. So the contempt decision, coming to a summary here, whose hands is the decision into? It's the judge and you. And it depends, as I said, a lot on who the judge is, not the institution of the court. And it also depends on how you react to it. One thing I wanted to point out is that the lawyers in these type of situations, they may have a conflict, because a lot of times lawyers, especially on these First Amendment cases, want to be, the white knight. They want to argue the big case, when your interest may be trying to find some accommodation so that you don't have an issue. So be aware of that. And I, as a lawyer, like tough questions from my clients, because it really forces us to think about things and think about all of the considerations that are there. But to me, ultimately, the decision about whether to comply with the subpoena, at the end of the day, if you can't talk the prosecutor out of it, or you can't talk the court out of it, which we've been successful in a lot of times, it comes down to the personal factors, right? The ones we talked about. How old are you? And, what do you have, a family? What's your health condition? All these sorts of things. So the summary is look, if you're going to resist a subpoena, call your lawyer. That's what I would say is the most important thing, because they can really help you and guide you through the process, and they can, respond in a way that's not likely to anger the prosecutor or anger the court, and help you through the process. But you should really talk with your attorney about what your particular goals are. Do you really want to be the journalistic superhero? Do you want to try a finesse way to do it? And it's important to understand, I should talk a little bit about those conversations between you and the attorney, if they are your attorney, are confidential. So they won't make it out usually won't make it out into the world at large. What else do we have to say in summary? Courts have a unique power to compel compliance, right? So it is one of the, a lot of times, a lot of the laws are passed with the legislature, the executive, and the judiciary involved. So you have a balance of powers, and the power is balanced out. In terms of the court's contempt power, it's really an power that's unique to the institution, and there's less checks on it than other types of powers. So what's the upshot of that? Be polite and be respectful. The First Amendment law, colloquially, it's a little bit of a mess. Probably need a lawyer to help you sort all that out. And shield laws, get them passed. That's something that's very important. I got another question here. What kind of lawyers' fees are we talking about? Do all lawyers offer pro bono to assist journalists with subpoena defense? How does a freelance journal with little or no funds approach being served with a subpoena? Oh, those are great questions. So let's start with, do all lawyers offer pro bono assistance to journalists with subpoena defense? The answer to that is no. Some lawyers do, and they're happy to help out in a subpoena situation. But a lot of times, the lawyers charge a fee, especially to institutional clients. There are some times that they will do pro bono work for journalists, depending on the cause and that sort of thing. I think it's important to have a First Amendment lawyer or a journalist lawyer, because they're going to be more efficient in doing this in terms of getting fees, keeping fees down, and trying to do it in a quick and efficient way. How does a freelance journalist with little or no funds approach being served with subpoena? Well, I think the subpoena, if the freelance journalist should talk to the entity that published the article, because often they'll have insurance defense money that will cover both the institution and the freelance journalist. You'll be an additional insured. It's what's known as an additional insured under the policy. So if you submit an article to like the Atlantic will, maybe have an insurance policy that would cover you and provide you with any sort of defense that you need to respond to a subpoena. But lawyers do try to help out in these situations and prevent that sort of situation from developing into something more serious. So if you do have any more questions, the presentation that I gave has my email on it. I understand it will be put up on the website, so you can get in contact with me that way. I'll just give you my number right now. The main number at the firm is 802-658-0220. That's another way that you can reach out for me. Please, I'm happy to answer any questions, and I do talk to people on a pro bono basis just to help them understand what's going on. So if you do have further questions about the presentation, I'm happy to answer that. And I appreciate your attention for the presentation.
Thank you so much, Matt. Appreciate it. Great stuff. A lot of information to have as we move forward here. And I would encourage everyone to reach out to Matt if you have any follow-up questions. I'll be providing this presentation online. Everyone will have a copy of it. I would also like to add that if any of you do receive a subpoena, a great place to start is with us at NEFAC. We have a very large board, a number of partner law firms, and a tremendous amount of resources that can help you. So please do reach out to us if you are in that situation, and we'll be able to assist in some way. Again, I want to thank everyone for attending this 30-minute skills class. We have these every month. If you miss any class, again, go to nefac.org. You'll find all of our previous classes there. And with that said, we'll see you next month for our next 30-minute skills class. Thank you.